All right. Good afternoon, everyone. This is Eric Kauge, Executive Director at Homeline, and you are joining us on Wednesday, September 16th at 1:30 in the afternoon for our weekly webinar series on tenant landlord issues in Minnesota during the COVID-19 pandemic. I'm going to get started here shortly after just a couple intro slides. Again, a reminder, Homeline is a nonprofit organization. We serve the entire state of Minnesota, and we've advised over 250,000 renters since opening in 1992. Our main program is a free and confidential legal hotline available in English, Spanish, Somali, and Hmong, where any renter can call and get free and confidential legal advice. And just a reminder that we have been doing these seminars, these webinars for free. They're publicly available every week since about mid-April, and we're doing one a week for up to 90 minutes every Wednesday. Recordings of previous seminars, most of the previous seminars are available on our website, along with a variety of materials, information, general advice on and information about eviction suspension, etc., and FAQs on a number of the topics that people ask questions about often. And next week, this week is primarily going to be a sort of an overview of what's going on with both the Minnesota suspension and the federal CDC suspension, as well as some updates on a number of lawsuits that have been filed recently that are that could impact tenant rights in Minnesota. So we're going to share a little bit about, Michael share a little bit about that. And then we'll have plenty of time to get to your questions, some submitted in advance, and feel free to send any more in that come up through the Q&A system or via over the chat system. And we'll get to those at the end of the webinar, where we'll have plenty of time to talk about those questions. Next week, we're doing this again. We've had guest speakers on for the past few weeks that were very informational and helpful. And again, those recordings are on our website. This week, no guest speakers, but next week we're going to have Michael Dahl in our office. He's our public policy director here at Homeline. And he is going to be sharing a little bit about sort of issues related to the ongoing peacetime emergency. So sort of logistical and political aspects related to the peacetime emergency. What other actions that the peacetime emergency provides for besides the eviction suspension, which has been the primary thing we've been talking about. And then also sort of with each of these votes that have happened with the renewals when special session has been called, just a little discussion about how close those votes have been during the legislative action that's been taken related to the suspension. So Michael will join us next week, and we'll have registration for that up on our website shortly. So with that, I'm going to pass it over to Mike Vra, Homeline's managing attorney and hotline director, to kick us off.
Thanks, Eric. And as Eric mentioned, we are going to be taking, we assume, a lot of questions today. We don't really have much more than about a half an hour planned of speech time, and there were a handful of questions submitted in advance, which we'll certainly answer. But if you do have a question, please submit it through the Q&A or the chat box, and we will try to answer it. We should have, like I said, we actually planned on this being nothing but a session of question and answer, more or less, but we decided that we needed to cover the basics of what's going on, plus the new court challenges that have happened that Eric mentioned that I'll get to in just a moment. But then we do want to focus on whatever questions you might have out there. So today's the day. You're going to be, your question will be heard almost certainly if you get it in either through the Q&A or the chat. But let's start by talking about where we are with the eviction question in Minnesota. It remains the top issue in landlord-tenant law in Minnesota and throughout the country, frankly, is a basic question. Can a landlord file an eviction? And in Minnesota, what we've talked about since we started doing these in mid-April is a series of hurdles that a landlord had to get past. And right now we have multiple hurdles that a landlord would have to get past in order to be able to file an eviction. The first is that Minnesota has its very own moratorium. This is based on a executive order from the governor, which is tied to the peacetime emergency declaration in time. And it essentially bans evictions for most of the key reasons. The number one reason, of course, being non-payment of rent, which accounts for over 90% of evictions in Minnesota. There are some exceptions. A landlord can file an eviction if a tenant is endangering others on the property, or if there's been significant property damage caused by the tenant, or if the landlord is planning to move in to the rental unit or have a family member move into the actual rental unit. There's logistics that have to be followed there, but again, most evictions are not fileable in Minnesota. The Attorney General, the state Minnesota Attorney General, has been enforcing this order. I still, in our office, at our hotline, we're sending people to the Attorney General's office on a daily basis saying, hey, look, this is a clear violation of the governor's order. Contact the AG's office, who in turn will contact the landlord if the tenant is okay with that, and explain what the rules are. So when does that moratorium end? Well, last week at this time, we weren't positive that the moratorium would be extended, but it has been extended through October 12th, 2020. So how the moratorium logistically works, the governor is allowed to renew the peacetime emergency declaration for 30-day increments. That's it. The governor can't go beyond that under the peacetime emergency declaration law that's been around since long before this pandemic occurred. The legislature has the power to end the peacetime emergency as well. And one of the things we're going to be talking about next week with Michael Dahl is that vote has been tightening at the state level. So how it works logistically, both chambers of the Minnesota legislature, the Senate and the House, would have to vote just by a simple majority to end the peacetime emergency. Since the legislature has been voting on this question since June, I believe is when they started, the Senate has voted to end the peacetime emergency declaration every time. The Senate, once again, controlled by the Republicans. The House, controlled by the DFL, is not voting to end the peacetime emergency. Obviously, the governor is a Democrat as well. However, in the House, the vote has been inching closer and closer to ending the peacetime emergency. And so it's a legitimate question to ask, what happens next time this comes up in October? Are a couple more votes going to peel away and the governor would lose the peacetime emergency declaration powers? We don't know, but it's certainly worth keeping an eye on. And it is the first and primary hurdle for any Minnesota landlord to file an eviction. As long as it's there, it's much more expansive than the CDC order. As long as it's there, a landlord can't file an eviction if they can't get past that first hurdle. The next hurdle is one that's quite a bit less important than it used to be, but it still has a bearing on what we're talking about. The CARES Act, which was passed, a federal law passed in March, banned evictions in CARES Act covered buildings through July 25th. So what's a CARES Act covered building? Any government subsidy involved, if there is a mortgage that is federally backed by Fannie Mae or Freddie Mac. But the July 25th deadline sunsetted, as they say in legislative speak. So that passed, it wasn't renewed. However, the CARES Act does have a 30-day notice requirement that a landlord is planning to file an eviction. So a landlord covered by the CARES Act, if the Minnesota moratorium disappeared today, might still have to comply with the CARES Act 30-day notice requirement. So that's why it still might play a role and be a smaller hurdle for a landlord to get past if the Minnesota moratorium goes away on October 12th, for instance. The last hurdle that we have is the new federal prohibition that went into effect on September 4th. It's an order that came, well, it originally began with an executive order from the president instructing the CDC, the Center for Disease Control, to consider, I think that was the word that was used in the executive order, to consider eviction protection or eviction moratorium and see what powers they had to do that. And the CDC order effectively bans non-payment of rent evictions only, just non-payment of rent evictions, through the end of the calendar year, through December 31, 2020. And so even if the governor's moratorium went away, most tenants in Minnesota, the primary reason why landlords would want to file an eviction, they haven't been paid maybe since March, is not allowed to file an eviction until the end of this calendar year. All right, why don't we go ahead and go on to the next slide. We'll talk a little bit more in depth about the CDC order. One thing about the CDC order that I should mention, and I've covered most of these points already, is just like the Minnesota governor's executive orders, there's no rent holiday. Rent has not been canceled. Rent is still due. This is something that occasionally we still get calls from. We got a lot of calls from tenants in March and April and even into May saying, wait a second, is rent due? I heard there was a rent strike. I heard that rent was canceled, so we don't have to pay rent, right? That's never been the rule. Not in this state, not throughout the country as near as I know. One thing I should mention, and this is a clarification that tenants have been asking us about a lot, what about late fees? Can late fees be charged? So under the CARES Act, that was the only one of the 3 hurdles that we had on the prior screen. Again, the state hurdle, the CARES Act federal hurdle, and the CDC hurdle. The only hurdle that we're talking about that ever stopped late fees was the CARES Act hurdle. It did not allow late fees in CARES Act covered properties. And again, we estimate 20 to 50% of Minnesota rental property would be covered by that CARES Act. It's a really difficult number to know. Nobody's ever really asked the question before this year who might fit in that category, and what it would require is to know what kind of mortgage a lot of private, small, mom and pop landlords might have. And it's sort of unknowable on a mass level. At least, I don't think there's some sort of Freedom of Information Act request that would even yield that information. I don't think so, at least. But it would be complicated to figure it out. But the CDC order, once again, only applies in states where there's no eviction moratorium already there, that the state doesn't have an eviction protection in place. And ours is clearly more protective of tenants, so there's no question that the CDC ban on evictions has no current effect on Minnesota renters. We get asked about this a lot. I think people find that on a Google search, hey, I haven't paid my rent, what can a landlord do? And they find that CDC order first. And they think, oh, this is what's protecting me. And it sort of is. It's kind of a safety net for tenants if the state moratorium goes away. But it has no legal impact today. So one of the things that the CDC order requires is that the tenants submit to the landlord a declaration that they're eligible for the CDC protection. And we've actually seen tenants filling these out, showing them to us saying, is this what I'm supposed to say? Is this how I'm supposed to write this? And our short answer is, well, you can do it, but it doesn't really mean anything legally right now because the state moratorium is in effect. Arguably, the tenant might have to redo it again. If the state moratorium got lifted, they'd have to reassert that they're covered by the CDC order because they're not covered by it currently. I guess that's the one cautionary bit of advice I'd give to a tenant right now on the CDC order is, even if you gave a statement of I'm protected or a declaration, you should probably give another one if the state moratorium is lifted, because that might be the key date trigger. A phrase that lawyers use frequently is something ripe. And I'm not sure it's ripe to give a landlord a CDC declaration as a tenant in Minnesota right now. Again, I don't think there's much of a downside to it, except it might make a tenant think that they're more protected than they actually are if the Minnesota moratorium went away. Okay, let's go on to the next slide. So wanted to talk about a couple court challenges. When we talked about the CDC order a couple weeks ago, I think we assumed that it would be challenged in court. I didn't know how quickly it would be challenged in court. I didn't know in what manner it would be challenged in court. And this is the one that we know about. We haven't done a lot of research on this because, again, this doesn't affect Minnesota renters. So we're not especially focused on the CDC order. I've read it several times and I've thought about it a little bit, and I've looked at a lot of articles talking about the impact of it. But as far as can somebody actually challenge this successfully, I don't know. I mean, my initial reaction to the CDC order was a couple of different things. Number one, it was incredibly sloppily written. It didn't resemble a law at all. Having read city, county, state, federal laws for my entire career, you know what laws look like. And this doesn't look like a law. It doesn't look like an executive order either. It's not enumerated effectively. It's really difficult to follow as a lawyer. And if you're not a lawyer, it's even worse trying to figure out what's going on in this document, which is dozens of pages long. But anyhow, a group that filed the first case that I know about this was filed by something called the New Civil Liberties Alliance, which is, I think, a libertarianish organization on the right-wing side, representing a Virginia landlord. They filed a district court case in federal court in Georgia. As near as I could understand, it's because that's where the CDC was located. That was some of their thinking. Atlanta is the home of the CDC. And they asked for a couple things, which is sort of standard if you're trying to get something stopped that's right away, that's taken place right away: declaratory and injunctive relief. So they're asking a federal judge to essentially step in and say, hey, this law I declare to be unconstitutional on a wide variety of claims. I mean, it's basically, if thinking back to law school, there's a class that you take in law school called constitutional law, and it seemed to be sort of a potpourri of constitutional law claims, something called the Supremacy Clause, and I can't remember if the 10th Amendment was in there or not, due process, eminent domain, that this is a unlawful taking of landlord property. To me, the most interesting legal challenge to the CDC order is the source of the agency that ordered it. The CDC ordering the eviction moratorium doesn't make a lot of sense to me, just from which agency should have the power to do this kind of question. I mean, I guess I understand it. The CDC does have some broad powers in dealing with infestations that you can imagine as some sort of disease that's carried by rats or bugs or whatever, and that the CDC would have power to deal with exterminating or infestations of certain animals. That seems to cross state lines and has some emergency portion built into it. But that's the law they're relying on, to say that the CDC has the authority to do this. That's what the federal CDC order is from. And so that's one of the challenges is, wait a second, should the CDC really be doing this? Clearly, I think that there's a much stronger argument that Congress could have passed a law similar to this, signed by the president, just like the CARES Act. The CARES Act was, of course, challenged, I think unsuccessfully, or people just lost interest because it had a sunset provision in it. But this one is being challenged, and it was challenged within a few days of the actual implementation of the CDC order. So will there be more suits that follow? I assume so. I think that there's likely to be more of these cases. I guess somebody could file one in state court arguing that evictions are state court they are state creations. Almost every eviction system, I think, in the United States is based on statute. I might be wrong. There might be some that are common law sourced, so they've been cases built up over the years, versus a specific state law that says how the eviction process works. But I think that every state has an eviction process that was declared by statute. So one could make an argument that a federal court or a federal agency shouldn't have the power to intervene in a state-created court system. So that might happen. There might be some state court challenges. There might be more federal court challenges. If the district court in Georgia doesn't like the New Civil Liberties Alliance, then we might see a case filed in California or in Missouri or somewhere else. And those are the types of cases that, if there's disputed decisions, if you don't get the same kind of answers throughout the country, then it's more likely to go up to the appellate level, the Court of Appeals, or even the U.S. Supreme Court. That's kind of really long-range planning speculation here, but I'm guessing that the type of folks that are filing cases like this are probably planning on ending up in the Court of Appeals at the very least, the Federal Court of Appeals, if not higher. Let's go on to the next slide there, Eric. Thank you. So I should mention another court challenge. So we talked about the Minneapolis tenant protection ordinances earlier this summer. We spent a good hour talking about this in one of our sessions. It was pretty much our most marked detour from COVID-19 specific stuff. So I thought it would make sense to talk about the fact that there's a court challenge. So this law has been in place since June 1, I think it was, in Minneapolis for larger buildings, 16 or more units. And it has a few key components, these additional tenant protections. One was a security deposit limit. So landlords could only charge so much for a security deposit. In every other city in the state, a landlord could charge infinite dollars for a security deposit. There's simply no cap. By the way, that's about half the states in the United States have a cap on security deposits on some level. So it's not like Minneapolis came up with a brand new rule. They just said, well, we're going to try this rule for our own spot. Additionally, there were limits on, substantial limits on tenant screening. How far a landlord could look back with criminal charges or for an eviction, or what they could use a credit score for, types of things. So there was a case filed, I think it was late last week, in federal district court, again, asking for injunctive and declaratory relief, asking the judge in federal district court, just literally across the street from the the district court in Minneapolis, which covers the state area. It's not a county court, it's a district court, but we have a state and a federal court right next to each other in Minneapolis. Anyhow, they're asking for injunctive and declaratory relief, asking that judge, that district court federal judge, to declare the Minneapolis ordinance unconstitutional. It's representing a host of landlords. This is very similar to the system that was used to challenge the Section 8 ordinance that the Minnesota Supreme Court ruled against the group of landlords a few weeks back. Minneapolis had adopted a Section 8 ordinance making Section 8 voucher holders essentially a protected class in Minneapolis, and landlords challenged that, and they actually won. The landlords won that case at the district court state level. So one judge agreed with them. Then the city appealed that, where the Court of Appeals, the state Court of Appeals, agreed with the city 3-0. The landlords appealed that. It went up to the Minnesota Supreme Court, where all 7 justices agreed with the city. So at the appellate level, it's 10-0 against the landlords on the Section 8 case. Now, this is a different case that's being filed, and it's in a different place. The landlords have filed it in federal district court instead of state district court. This is sometimes done by lawyers where they think that they have a more likely chance of success at the federal level. I'm guessing that was the line of thought. I certainly haven't spoken to the attorneys. I don't know them that are representing the landlords in this case, but that's typically a thought process that they go through. Reading this court challenge the other day, having just read the case filed in Georgia challenging the CDC ban on evictions, it struck me the similarities in arguments. Essentially, the taking of property is kind of at the core of what this challenge is that Minneapolis has taken the landlord's property by taking away their right to ask for a bigger deposit, taking away their right to do whatever tenant screening they wish to do. I'm not exactly sure where the case will go. Obviously, the city will, I assume, defend the case. And if one side or the other loses, I'm not sure if it will be appealed to the federal appellate level. Maybe the landlords thought that it's got a more receptive chance of success based on who they think the judges are that might hear it. Hard to know. But it also struck me that reading this case, I think a landlord or a group of landlords or a lawyer for a landlord could make the arguments that this group of landlords are making in their case about virtually every landlord-tenant law in Minnesota and probably throughout the country. Let me give you an example. Landlords aren't allowed to lock out tenants. What do I mean by a lockout? A lockout or an ouster is where a landlord just changes the locks on a tenant, right? And we still deal with this, by the way. We get 500 to 700 calls a year on our tenant hotline where a landlord has threatened a lockout or actually done a lockout. Or they've turned off the utilities, turned off the water, the gas, the heat, whatever. So these stories almost always start the same way. The tenant hasn't paid the rent. Okay, that's bad. The landlord is upset. And so the landlord because the tenant hasn't paid the rent, thinks, well, wait a second, they are supposed to pay the rent in order to be able to live here. Since they haven't paid the rent, I'm not going to let them live here anymore, so I'm going to go change the locks. Again, this doesn't happen every day, but it happens. We get calls on this, and certainly landlords threaten it a lot. That's not allowed legally, and it hasn't been allowed legally in Minnesota for a long time. But it used to be legal. It used to be legal in Minnesota and every state in the country that a landlord could physically remove a tenant instead of going to file an eviction or an unlawful detainer or whatever it's called in whatever state you might be in. It was a right, it was a property right that landlords had before, that on some level, state or a county or a city said, you know what, we got to have a little more protection for renters here, and we don't want that kind of friction. We've seen too many fights happen when landlords go over and physically remove tenants, so we want to minimize the physical contact. Let's have the state step in for something important like this. We're going to have both sides play by a bunch of rules. We're going to give landlords a really fast eviction process, a court process. And in exchange, they give up the right to lock somebody out and throw them out physically. But again, it's a rule that changed. Landlords used to have that right. And so, again, taking this sort of to an extreme argument, a landlord could argue, wait a second, the anti-lockout, the anti-ouster rules in Minnesota are taking away a right that landlords used to have. That's a property right I used to have. I should still have that right. And so if you think about what landlord-tenant law really is, first of all, it didn't exist 200 years ago. There was no landlord-tenant lawyers in the United States. It would have been just a foreign concept. It was a contract between tenants and landlords. The court enforced the contract. And what landlord-tenant law has tried to become or tried to do since then, and certainly in the last 85 years throughout the United States, is it's tried to figure out a way to come up with a balanced playing field between the lord of the land, which sounds really powerful, and whatever the tenant means, a lesser partner in this agreement between a landlord and a tenant. Largely because, well, housing's such a big deal, right? I mean, this is the biggest expense in almost everybody's life. If you don't have a place to live, everything else starts to fall apart pretty quickly for most people. And so there's this sense that, all right, housing needs to be somewhat protected. So, and you might be thinking, well, wait a second, Minnesota is this bright blue liberal state that bends over backwards to help every tenant in every case. And we have done comparative analysis on statutes throughout the United States for a lot of different reasons. And it's simply not true. Minnesota's somewhere in the middle on most topics when it comes to landlord-tenant rights. It's just not as far blue as landlords would tell you that it is. It isn't, not compared to other states. But every state, every county, every city is trying to figure out what's the balance, what's the level playing field that we think sounds fair. And it's basically states and cities trying to come up with stuff that balances out a system that was completely in favor of landlords 200 years ago and finding that middle ground wherever that might be. These laws that I'm talking about, by the way, even though the deepest red Republican, most conservative states still have landlord-tenant protections in place, almost always overriding whatever the lease might say on the key core critical issues like evictions, security deposits, repairs, things like that. So this is just what's done, is there's been regulation in the landlord-tenant arena. And reading the complaint from the landlord group, they seem to be arguing that again, I think if you just inserted any issue about landlord-tenant law into their argument and took out what the Minneapolis ordinance is, it would read the same, that there's overreach by some legislative body interfering with a contract. That's pretty much what they're saying here, depriving the landlord of property that they used to own. I'm not saying that means that they'll lose their argument. It's just that it's sort of challenging the whole concept of landlord-tenant law in a way. Anyhow, that's a long history lesson about something that nobody probably asked for a history lesson on, but that's what happens when you give a lawyer a microphone and half an hour to fill talking about a couple things of recent importance. But I think I'm going to get a drink of something and Eric's going to talk, and then we'll talk about questions that we've got.
Yep, thanks, Mike. So yeah, we're again, we've had busy agendas the past few weeks with some great guest speakers. Not to say that Mike talking for a half an hour about legal history.
Every time.
But we do have some questions that were submitted in advance, and so we're gonna tackle those first, and then I've seen some come in already over chat, so we'll get to those as well. But this is your opportunity to ask any questions about tenant landlord law. I mean, we'll cover pandemic related eviction suspension stuff quite a bit. If you have questions about that, or just generally, if there's tenant landlord questions or questions about these challenges. So kicking off the questions submitted in advance. So Karen just asked, last Friday, the 11th of September was the end of the peacetime emergency, was the eviction suspension ban extended.
Yeah, it was extended another month through October 12th, and I certainly don't mind sort of going over things that we've talked about before. It's the number one issue still is there a Minnesota moratorium? It's the starting question, so it's the most important thing I think we've addressed since we started doing these presentations. Do you remember what the exact vote was in the House on this last go round, Eric?
I can get that 1 second, and then sure. The other thing is I will post it was Executive Order 20-89. Does that sound right?
Right. So if you're reading executive orders, you can actually Google up all the executive orders that the state has ever issued. But how it works, if you're reading an executive order, it's EO, so executive order 20, EO-20, so that's 2020, and then dash whatever number we're on. And I think we're up to 89, that's the last I looked. 89 executive orders in 2020, which is an extraordinary number, obviously, because these are extraordinary times. But that is the one we're on right now, and that's the peacetime emergency extension is the 89. The eviction moratorium, I think, is tied to still, is it 79? Is it 2079, I believe?
Yeah, 20-79 is the eviction suspension.
The most recent eviction.
Right. So that went into effect August 4th and did away with the earlier suspensions.
Right. It's been modified a couple of times. That's why there's more than one eviction moratorium. In general, they've been tied to the peacetime emergency, but that's why it's got a later entry in the list of EOs. Yeah.
So the yeas in the House on September 11th was 64 yeas.
And how many nays?
That I don't have. I'm sure it's findable. I just don't have it in front of me.
Right. Yeah. And I know I knew that at some point, but
here we go.
We'll talk about it with Michael next week, obviously.
All right, here we go. 64 yeas and 67 nays. So again, this was it was a little, I think it was a little different this last round. It was like a motion to suspend the rules or something, but basically it was voted down to move towards the action of ending the peacetime emergency because the Senate.
But that means it's 2 votes difference. I mean, it's 3 votes, right? 67 to 64. But if 2 votes change, then that would be a difference maker, right?
Yeah. Yep.
Yep. That's all it would take from what we had this last go around. And the votes have not always been this close. So that's why I was talking about them constricting. And one of the reasons we're going to have Michael Dahl, our public policy director, on next week is to talk about what's happening at the legislature. And again, one might think that, okay, well, we got the CDC moratorium in place through the end of the year. So what's the big deal if the state ends the eviction moratorium? First of all, the peacetime emergency is not just about evictions. Honestly, that's very much on the back burner of most people's minds that are talking about this. It's things like restaurants reopening fully and mask requirements and things like that. And so there's a lot more to it than just the eviction moratorium, but it certainly does matter. And there's no question that the Minnesota eviction moratorium is much stronger from a tenant perspective than the federal one. Much more protection built into it.
Yep. And I did in the chat earlier put the link to our general COVID related legal issues page, and that has a variety of materials and sort of updates on what the current status is, links to the FAQs about 2079 and others, as well as information about the financial emergency rental assistance resources that are available. So that's where you can find that. And we do actually have an update on that page, as we do also on our social media, about sort of that position in terms of the CDC moratorium versus the Minnesota one, and effectively saying, it's not relevant for tenants right now, and they should be relying on the state one. So the next question came in advance from Drew. Is lying on a rental application about prior evictions sufficient grounds for an emergency eviction in Minnesota?
Yeah, I thought about, and I saw that question in advance, and I thought about it a little bit as well. I'm going to answer this sort of in a COVID and a non-COVID era. So in the COVID era, I don't think you'd win as a landlord filing an eviction for that reason. So the closest I can get with the Minnesota moratorium being in place to a landlord having a shot, I'm putting on my I'm a landlord attorney hat for a second. I've never been a landlord attorney, don't plan to ever be a landlord attorney, but I mean, I know a lot of them, and I have to think like them because that's how lawyers think. You have to think about what's the best version of my case, what's the best version of the other side's case. And so I thought about this sort of as a landlord attorney. And I thought, well, I think the closest you could get is that the tenant is seriously endangering others on the property. I just don't think that works. I don't think that that's there. I mean, at its worst, that would be fraud. Somebody lying on an application trying to qualify for rental housing, which is a criminal act, depending on the level of value of what you're trying to gain is. But that's not covered by the governor's order. It doesn't say you can be evicted for any crime you commit. It's for seriously endangering others on the property. And I just don't think lying on a rental application would get to that level. I would bet heavily against it if a landlord filed an eviction and that was the reason they listed. The only other real exception that works, or that a landlord would argue that works, would be that it somehow falls under a specific landlord-tenant statute, 504B.171, which has a list of reasons why landlords can file an eviction: possessing drugs in a rental unit, illegal weapons, engaging in prostitution, possessing stolen property, or some parts of domestic abuse. That doesn't fit in there neatly. So today, I don't think a landlord wins an eviction if they file it for that reason. I just don't think that they'd win the case. I should mention, and Eric, if you can find 504B 173 and post a link to that, that's the application fees statute. There is a penalty built into the state law on applications that talks about a $500 penalty if a tenant lies on an application, which, to be fair, I don't know that I've ever seen a landlord go after a tenant for, at least file an actual court case. It'd be really hard to collect it, most likely, because somebody lying on an application to try to qualify for rental housing, you might not even know their real name. So suing them for $500 in a civil court, like conciliation court, might be somewhat fruitless. But anyhow, that is one of the penalties that is out there. Now, going out of the COVID-19 era for a moment, on Drew's question, is lying on a rental application sufficient grounds for an emergency eviction in Minnesota? Is it grounds for an eviction? Most leases would say yes, that I see that landlords use. But an emergency eviction? I don't think there's an emergency eviction available, because in that setting, in non-COVID-19 world, the only emergency evictions are the ones that I mentioned. Engaging in prostitution, possession of stolen property, possession of drugs, illegal drugs, possession of illegal weapons. That's it. That's the only ones where an emergency eviction is possible. So in general, the answer is no, a landlord can't file an emergency eviction for that. Can they file an eviction? Sure, and evictions are pretty fast normally. I have no idea how fast they're going to be once the courts open up again. It used to be, my answer was 20 to 30 days from the day a landlord files an eviction to the day that it's over, but I have no idea how long it'll take once the courts open up and what just how the process will work, how quickly it'll go. But short answer is I don't think that's enough for a landlord to win one of these cases, Drew.
All right. And let me flip to the next question here. Okay. The next question is from Selena. Selena lives in an artist loft community style housing. They share a community restroom and kitchen with multiple people in the larger building. They don't provide any housing essentials such as cleaning supplies, soap, toilet paper, or anything to help fight COVID-19. I'm wondering what I can do if the landlords haven't provided any COVID-19 protective measures for those. So again, these are like community restroom and a community kitchen.
So my first thought, the question came from somebody named Selena, is I'd need, if somebody called our tenant hotline with this story, I'd need to make sure they're a tenant. I'm not sure that they are. This might be a co-op, which are bizarre rules, if there are any rules. We don't really specialize in co-op living, but I'm assuming that everybody pays for their own room. And, you know, as part of it, they get this shared common space, which happens quite a bit more than you might think it happens throughout the state, especially if there's larger, older houses. In that situation, is it the landlord's job to provide cleaning supplies and protective equipment? I think that's a tough argument to make. One of the things that Selena listed, I don't think you listed everything she talked about, but she said cleaning supplies, soap, toilet paper. If the landlord promised these things as sort of part of the original deal, then I think, yeah, absolutely, the landlord's got to live up to it. I have a hard time imagining if somebody had moved in prior to COVID-19 that the landlord had promised to provide hand sanitizer, because that's kind of a modern, and by modern I mean the last 6 months, obsession for us. I do think that the mask requirement, the governor's executive order on masks, might require mask wearing by all the tenants in the common areas. I think there's an argument for that. I think that's absolutely true in lobbies of large apartment complexes, and it might be true in these shared spaces too. So what I'm thinking of is kind of the prototype in my mind of what Selena's describing is it's a 6-bedroom, big old house, right? Where everybody has a lock on their bedroom door, but everyone shares the kitchen, they share the bathroom, they share the living room. Reading the governor's executive order, which I think is 81, it might be true that they have to wear a mask in the common areas there, in that shared space. So anyhow, I guess a tenant could try something like a rent escrow where they force the landlord to make these repairs or provide these supplies that they think that the landlord should be supplying. But unless the landlord originally promised to provide them, something like toilet paper, I've never seen a rent escrow filed for a landlord not providing toilet paper before. The cleaning supplies is probably a better argument, but I'm still not sure that that's a winner. It really probably hinges to some degree on what was promised as part of the original deal.
So yeah, our tenant hotline phone number and email and attorney information is up on your screen. So if you had that question, give us a call and maybe we can go through the.
Yeah, we'd want a lot more detail to give a fuller answer. Absolutely. Good point, Eric.
Next, and a reminder, we've gotten some that's sent in, but feel free to send your question if you have one. We got some more in advance, a few questions from Linda. Can you clarify about if someone on subsidized housing can or cannot get emergency rental assistance through the state? So the state Minnesota Housing CHAP program. That's the I think COVID housing assistance program that we had folks from Minnesota Housing on a couple weeks, 2 weeks ago, I think, sharing about that program.
I'll let you take this one. This is your department more than mine. So
yeah, so I'm going to send out the information again in the chat about that program. I think your best bet is that you call and go through their the 2-on-1 preliminary eligibility screening is I think probably your best bet on that. I think what I recall from that discussion is that the program is not available to folks that have a housing subsidy, and I think in many cases that's because a housing subsidy might make up for the loss in income. It would be based on your income. And that's what it says actually on that page that I just linked you to. If you currently receive rental assistance, if you currently receive rental assistance that adjusts with income. So for example, Section 8 voucher, project-based assistance, public housing would fit in that. You are generally not eligible to apply under this program. It does say that you can apply for eligible utility expenses. But there's a lot of different rental assistance programs, and so it's probably about it's a good idea to get advice on this. Go through the process to apply, because or at least the preliminary screening process, because you may be in a unit that that isn't income. That doesn't adjust with income. There's certain programs that are run like that. So that's I think the best response to that. Another question. Okay, could you clarify about if a tenant applying for the new CDC tenant eviction protections must have extraordinary medical expenses due to COVID, or just extraordinary medical expenses of any type? It would be good to know what they mean by extraordinary.
Yeah, so, and I got this question in advance, so it gave me a chance to look it up, because this isn't like the Minnesota moratorium, which I know really intimately because I look at it a lot. The CDC order simply doesn't really matter for Minnesota renters, which is all our office advises. But I did look it up. And so I can tell you exactly what an extraordinary medical expense means. It's defined. Those of you reading along on the CDC order, it is the 38th footnote, and it's just a sentence, so I'll just read it. An extraordinary, in quotes, medical expense is any unreimbursed medical expense likely to exceed 7.5% of one's adjusted gross income for the year. So it's really about amount is what they're talking about. And it's got to be 7.5% of one's adjusted gross income for the year. It's quite a percentage. It's pretty high, but for a lot of medical bills, that'd be easy to reach that threshold. That's the short answer. That's the extraordinary medical expense definition.
And there is a form that I think this was created by the CDC, and I'll put that in I put a link to the
declaration form, you mean?
Yeah, there's a declaration form that actually, is in other states. That's what people are filling out, and that's where it actually cites. If you sign that, you are agreeing to what it says in there, and one of them does cite to that extraordinary medical expense.
Yeah, when looking at the CDC order again several times now, probably the only thing I can really, I like the concept of it. They're trying to say, hey, look, we're trying to protect people in their homes. We're trying to stop the spread of people physically, because that'll hopefully stop this virus and we can all get back to our lives again, hopefully someday. But it was so sloppily done. But the one thing I will commend the CDC for is they actually created a form. They didn't say tenant has to declare stuff and here are the key elements. They said, here's the form, use this form. So then a tenant isn't guessing that they're getting it right, and a bunch of creative lawyer types out there like me would overthink it and come up with stuff that shouldn't be there or omit things that should be there. They said, this is the form to use. So it is, I like that kind of direct approach that order takes.
Lawyers overthinking things.
They sure can.
And then Linda actually chimed in the Q&A and said, regarding the first question about applying to the state program, 211 is in their preliminary screen, when you call them, is saying only energy assistance for folks that have income adjusting subsidized housing programs. So again, a lot of those income adjusting subsidized housing programs are going to do just that, adjust with your income. And so then in theory, benefits by having a lesser amount to pay in rent. But depending on what your subsidy is, since there are a lot of different ones, you might want to discuss that. And then
Hey, Eric,
follow.
before you get to Linda's next question, somebody, an anonymous person, just submitted a question about retaliation. If you could, please do me a favor and send in how you think the landlord is retaliating, like what retaliatory actions they're taking. And then we'll get to your question after a couple other ones. Sorry, go ahead with Linda's.
Yep. And then, okay, so this is jumping again, sort of back to the tenant declaration. If tenants are in a college dorm house type situation, so maybe multiple roommates or something like that, does one adult only, or the group of separate adults need to fill out the affidavit?
Yeah, so again, I looked at the CDC order to make sure I knew the answer to this question, and it's all the adults on the lease is who needs to fill out the affidavit. In that college setting, the key question in my mind would be, is there one lease or separate leases? It does happen sometimes where tenants will have separate leases in the same, what looks like a house. Again, think about a giant house where there's 6 bedrooms and people share a kitchen or bathroom. There might be 6 separate leases there instead of one lease where everybody signs it as one. The default is everybody signs it as one. That's what most landlords do, but it's not exclusively like that. So that's the first thing I would ask a tenant in that spot is, hey, show me your lease. Is it just you on there, or is it you plus your other 5 roommates? And if it is, then all 6 roommates are going to have to make that declaration.
All right. But again, it sort of, I guess, just jumping back to what we talked about earlier, I think, the sort of general advice right now is that in Minnesota, you're protected by the state moratorium. So it maybe is not necessarily in individuals' best interest. It's always dependent on their specific situation and what they're declaring to on this form. But right now, in Minnesota, you don't need to do the form to be protected by the state suspension. And so, get legal advice about your individual circumstances.
Mm-hmm. Absolutely. Thanks.
And somebody did clarify about the retaliation thing. So we'll get to that question next after this one. Sheila had chatted in, jumping back to the slide about the legal challenge on the CDC suspension. How long would this CDC legal case filed in Georgia take? Would a decision be made by this December, which of course the CDC suspension goes until December 31st of this year?
Yeah, it could. It absolutely could. Look, I don't work in federal court. I'm not licensed in federal court. It doesn't take a lot to get licensed. You have to essentially get some vouchers from other lawyers. You don't have to take a special bar exam or anything like that. But it's never been something I've needed to do for my line of work. So I don't practice there. But just reading about cases, through my career that have gone through the federal court system, when somebody files for an emergency declaratory judgment like this, or an emergency restraining order, it can happen really quickly, but the courts tend to have some ability to think about the case. I think the Georgia case is almost certain to be appealed by whichever side loses. I'd be shocked if it isn't. And it might be appealed all the way to this, U.S. Supreme Court. And it might, like I said, be challenged in other federal jurisdictions as well. So could a decision be made by December? Absolutely. It could be made in September, I think, at the district court level for sure. Could be made this week. They can happen pretty quickly. They expect quick turnarounds. There's a limit to what they'll look at. But how they generally do these kinds of cases is they look at them and say, do you have any shot of winning at all, landlord group? And if they think the landlord group does not, they can rule against them pretty quickly. And if they think that the landlord group has a chance to win, then they might say, all right, well, let's have actual arguments and get past this preliminary stage. But we'll set them on really quickly. So it's hard to know where this is going to go procedurally, but there's every possibility that there could be a meaningful court decision. By meaningful, I mean it would have some authority, but well before December, or else they wouldn't have bothered doing it. The landlord rights group wouldn't have bothered doing this in Georgia. There would have been no point to it.
All right, so that's what we have so far submitted. We'll get to this retaliation question again. If you have questions, we'll stay here as long as there's questions coming in until 3. So there's a question about retaliation. What options do tenants have in general when they feel their landlord is retaliating against them? For example, a landlord towed a tenant's car and claims it was because of expired tabs, and then the tenant not paying for their parking spot.
Yeah. So we get, I don't know when we made towing a category for our tenant hotline sort of database, but we've had it for a category for probably a decade now, because we get a lot of calls about towing in our office where a landlord has towed a car. So, and I don't think this is anything we've talked about on any of our sessions so far, so I'll just give a little intro to towing in the landlord-tenant world. So a landlord generally is not allowed to tow a tenant's car unless there's something in the contract, the lease, that says under what conditions the landlord is allowed to tow. And then the landlord actually follows through on their conditions. There are 2 most common approaches that landlords take when it comes to towing language in their lease. The first one is an automatic trigger independent of the landlord. It's about snow, right? No big shock in Minnesota that we care about towing during snowstorms. So what the towing rule will say about snow is that if there's an inch of snow, according to the whatever weather reporting agency might be out there, within the last 24 hours, the tenant has to move their car until it gets towed, and then they can move the car back, something like that. The other type of towing clause in a lease will say that the landlord has the right to tow, but they will warn the tenant at least 24 hours in advance that they'll tow, or overnight, or whatever. So step 1 is the landlord has to have the right to tow based on the lease, and step 2 is they have to follow their own rules. Surprisingly, it's not always what a landlord does. They don't always follow their own rules. If they have a rule that allows towing, there are a lot of towing lawsuits in Minnesota. In conciliation court, I think it's a day and a half, or maybe just a day that they, in Hennepin County at least, where they do nothing but towing cases. Now, these aren't all landlord-tenant cases, but people that think they were towed unfairly, because it's a lot of money that we're talking about generally. This is an adversarial tow or a confrontational tow. Towing companies charge more for those, versus if your car breaks down and you want to have it towed to the mechanic, that's somebody who's actually owning the car saying, I want it towed. They don't charge you as much for that tow versus a adversarial or confrontational tow, because there might be heightened danger for the towing companies. They can charge double, is what I've seen some of the time, for towing somebody's car when they haven't authorized it to be towed. So the towing company will charge $250 to tow the car, and then charge a storage fee, a daily storage fee, $10, $20, $30 a day, whatever it is, on top of it. And we've had clients that have actually just given up their car. I can't afford to get it out of the impound lot. I know it's worth $3,000, my car is, but this towing bill's up to $600. I was out of town for a few days, and by the time I got back, they had it, and I didn't have the money to pay to get it back, and so the bills just kept running up on it. And so a lot of tenants do go to conciliation court about this. Now, that's not really answering the retaliation question directly, but I'll try to do that now. Can a landlord be retaliating, or would a court say that it is retaliation for a landlord to tow a car and claim that it was because they hadn't paid, the tenant hadn't paid their parking fee or rent, or they had an expired tab, or the tires are down, or it looks inoperable, it hasn't moved in 3 months, or whatever? Once again, the landlord has to follow their own rules. So if a landlord wants to tow somebody's car for an expired tab, it needs to say that in the lease, that they can tow for an expired tab, or because of a flat tire for a week or longer, or whatever. And that would be my first legal question. And this is one of those things where I'd want this person to call our tenant hotline, walk through it. Again, we're free, we're confidential. We're not going to call your landlord and tell them what you said. We're not going to call the mayor or the governor or the attorney general. We have attorneys on staff, and we have other students, law students, a lot of them. And every one of us is bound by attorney-client confidentiality. So somebody's sending an anonymous question in right now. I certainly get it. This is a public forum. But if this is actually happening to you, we'd love to talk about all the details of your case to figure out what makes the most sense going forward. Using retaliation as a defense I get the notion of it in my mind, but retaliation is typically a defense used to fight off an eviction by a landlord. So although we might consider the statutes, the first thing I want to think about is, all right, could they tow legally at all? And if not, how do you build up the case? By the way, had several cases this year of expired tab towing, largely because it's taking so much longer to get tabs this year than it has in most years. People sending away for them. And so if that's what's going on, I've had a couple of tenants that have actually submitted to their landlord the paperwork proof while they're waiting for the tabs to arrive. And so it's worth thinking about if you've got a car where tabs are going to expire, stopping in as a tenant and telling the landlord, hey, the tabs are coming. Look, I've done everything I could, but don't tow my car. And landlords should have the ability to put a car on the no tow list with their towing provider. Almost every landlord goes with one towing provider that they have sort of a relationship built up over time with.
All right. We have another question that came in over Q&A.
And that's our last question in the queue. So again, you got a landlord tenant question. Here's your chance. Free chance to talk to a lawyer.
Or if
or an executive director. I don't mean to cut you out of there.
No. Or if you have thoughts on you know, a bigger topic that you'd like us to cover in a future session, you know, send that in. We want to make sure that these are helpful and that they're getting important information out to the public. And so that's why we've been continuing them since April and having a variety of guest speakers join to talk about different aspects of the pandemic, but also a number of other issues. So next question, and the last question that's in the queue right now, brings up a scenario. A plumbing issue in a building causes water leak in several units. The property manager fixes the plumbing and replaces the floor, but they tell all but one tenant that the water needs to dry before the flooring can be replaced. For this tenant, they replace the floor right away. The tenant is worried that there is mold under the floor from not drying. Should the tenant begin a rent escrow? And is there any third party that can inspect the work?
Okay, a lot of stuff built into this question. So I'm going to start by just mentioning that mold is a question that we get asked about a lot, a topic that we have a lot. We keep track of why people call our office. And in a normal year, a non-COVID year is what I mean by a normal year, repairs is always the #1 reason that people call us. Well over 1 out of every 5 calls are about repairs. We have about 75 categories of calls that we sort of label. Towing was one of them. It's not one of the higher ones, volume-wise. Repairs, evictions, security deposits are the top 3. Every year they account for close to half the calls that we get. But repairs is #1, virtually every time. And mold comes up in about a quarter, a little more than a quarter of our repair calls. People are asking about mold. I've been doing this work since 1996. When I started, mold was not something that we got questions about. It just wasn't. We'd get some, but it was a different era. And you could argue about why that's the case. Some people believe that it's because they've started building tighter buildings where there's less air going in and out. I'm not sure if that's really it, or if people are just more aware of mold in general and more nervous about trying to solve it on their own. I can remember an apartment I had at some point in my early 20s where we had some mold in our bathroom, and I grabbed a spray bottle, put a little bit of bleach in it, and sprayed it. And I'm not even sure I used gloves, maybe, certainly not a mask. But we did it in this place that we lived at for 3 years. We probably did it 4 or 5 times, or I did it 4 or 5 times. And I think that's just what people used to do when they saw mold, is they just, try to solve it, not realizing the potential health issues that mold might create. So mold has become something that people are much more aware of, for sure. Mold is also a really hard thing to solve in landlord-tenant world. And the main reason why it's a hard repair problem to solve is because inspectors are reluctant to note it in a way that helps a tenant. When I talk about inspectors, I'm talking about city inspectors. These are city employees, and many of them have been instructed by their bosses not to write down the word mold or mildew or anything like that in an inspector's report because they're not mold experts. They haven't used a mold testing machine or device to determine not only is there mold, but what type is it and how much is there. There are mold machines where mold remediation experts will come out with this machine, set it up, and it basically vacuums a lot of air in, and it'll tell you what kind of mold is in the property and how many parts per million as well. But those are expensive. Most of those mold tests, I think you're looking at several $100s at least. There's no agency that I know of that does this for free. It's one of the things that I've told cities that have talked about how would we improve our inspections department. I say, get a mold machine or two and have them bring them out. When people talk about mold, they could, issue reports saying what the mold is, because it's an expensive process. People are very concerned about it, but cities don't do that as near as I know. I think it'd be great if they did, but they don't seem to. So should the tenant file a rent escrow was a direct question that we got. This would be a really hard case for a rent escrow based on what we have in front of us, is that we think that the landlord replaced the flooring more quickly in one unit than others. The landlord would undoubtedly say, oh, we had a good look at it. We had our flooring expert look at it. They're not concerned about it. That was the dry one. All the other ones were really wet because they got it worse or whatever. And so we're not worried about the mold. If a tenant did file a rent escrow, the only way I think it would have a chance of succeeding is if they could show mold existing prior to the replacement flooring going in, or later on that mold starts to creep around the edges. And pictures work a lot when it comes to mold cases for tenants. A judge is going to look at a picture showing a bunch of stuff growing on the floor or on the wall or wherever, and the judge isn't going to know if it's mold or mildew or whatever it might be, or what type of mold it might be, but they are able to look at it and say, hey, I don't think that looks right. Landlord, you're going to have to fix it and do it right. So photos mean a lot when it comes to mold. Maybe the most important thing a tenant can do, other than those really expensive tests. And photos are critical because a landlord will come in with a bleach bottle and spray something, and then depending on what we're talking about, they might apply some paint or something on top of it that's supposed to repel mold, which only works for a while. You have to, as a landlord, you have to figure out where the moisture is coming from, or else the mold will recur. It's just a matter of when.
All right, a couple more questions have come in.
Yeah.
If a resident did not sign an addendum for a parking spot and the lease says that they do not have a parking spot, after 2 months, can they charge for past garage rent if nothing had been written up or signed? And then a follow-up on this, what would a notice period be for adding the garage onto the lease? It's a shared underground parking garage. So there was no original lease, had no addendum.
Yeah. So again, this is one of those cases where we'd like it if the tenant would call our tenant hotline, because we'd be able to have a conversation versus this back and forth, which is a little bit strange for a way of communication. I don't mind doing it. It's just that I'm missing details that matter, I'm sure. So I'm not sure if the tenant has been using the underground parking garage space for those 2 months. If they've been using the garage space, I think they owe something. Like a judge, small claims court would almost certainly say, kind of on a fairness level, hey, you've been using it, you should have had to pay for it just like everybody else. I mean, the landlord can't ever make a tenant sign an addendum midway through. I mean, if the tenant doesn't have a car, I don't know why they'd have to sign the addendum. But if they do have a car, they're using the garage space, they're kind of getting the benefit of the deal without paying for it. I don't know. If the lease originally said that the tenant was promised that indoor garage space and that didn't mention anything about a charge or an addendum, then I guess the tenant has a much stronger argument. But this is pretty fact specific and maybe even lease specific that we'd want to see the lease. So you've got the how to email an attorney directly or call our free tenant hotline. Both services are free. I'd recommend emailing because we'd want to see both the original lease and the correspondence about this between you and the landlord, whether it's texts or emails, along with the addendum, to be able to give you much more targeted, useful advice than I can give in this kind of setting.
All right. Not seeing any more questions in the queue. but we'll just talk for a minute here about next week and wait in case there's any other questions or comments that come in over chat or Q&A. Yeah, again, reminder, next Wednesday is September 23rd, and we'll host another seminar, another webinar next week, and we'll be joined by Homeline's Public Policy Director, Michael Dahl, who'll be sharing a little bit, as we discussed earlier, about the peacetime emergency and sort of the logistical and political aspects that are surrounding that, in terms of what does it cover, what does it, in addition to the eviction, allowing the eviction suspension to progress and extend 30 days at a time when it's extended. What other issues does it tackle, and then also what the votes have been at the legislature on it, and sort of the discussions around that.
Yeah, we've never really talked about the political side of that on any of these sessions. We've been very focused, almost mechanic-like, on the logistics of all of this. So I'm looking forward to that conversation.
Yeah, and so that'll be next week, and we will send out, it's not posted on our website yet, but we'll get that up, and we'll send both a link to the registration for that and the recording for today to attendees from today's event. Do see a couple questions that popped up here. What's the best way to enforce a walkthrough with proper notice if a tenant denies access into their unit?
So what I think a walkthrough means here is a showing, I'm guessing, versus an inspection. What do I mean by that? A showing is where a landlord wants to show the rental unit to a prospective new renter. We're going to assume for a second that the current tenant is leaving at the end of next month. The landlord wants to re-rent, and the only way they think that they can do that effectively is to show the actual unit to the prospective new tenant. So I don't think there's a way for a landlord to force this right now in COVID-19 era rules. Eric will post our position paper on when a landlord is allowed to enter, a question that we addressed April. I think we officially posted that paper saying what our views were on that. I think that's when we posted it originally, and we've updated a couple times since the laws have changed. So here's the problem that a landlord has when it comes to entering a unit right now. Normally, a landlord under state law is allowed to enter a rental unit under certain conditions. If the landlord is given a proper notice, a reasonable notice is how the wording is described, and also has a reasonable business purpose for entering the unit. And that is analyzed, both of those terms, reasonable appears for business purpose and for amount of time, in our new era, the COVID-19 era. What is reasonable for a landlord entering? Well, a couple things. Number one, the landlord and their agents and their guests, I believe, have to wear a mask to enter the unit. Can't do it without wearing a mask under the governor's mandate. But number two, what if the tenant blocks the door? No, you can't come in. They move their dresser in front of the door. What can a landlord actually do at that point? If they try to break in, the tenant's going to call the police. The police are going to come out and say, we don't really want to get involved. If you want to do something here, landlord, go file an eviction. Problem is, the landlord can't file an eviction for this right now. So there's not much of a remedy that the landlord really has for the showing here. Showings have always been a friction-laden issue. The whole concept of landlords entering with their key is something that we have dealt with in our office since I started working in '96. And it's always a point of contention. I've seen a little bit more of this since COVID-19 has happened, where landlords are treating tenants, current tenants, on some level, sort of like showing helpers or showing agents, which, look, I have told, and those of you that have read either of the books that we've produced, The Landlord's Guide to Minnesota Law or How to Be the Smartest Renter on Your Block, one of the things that I have always tried to explain to tenants is they have an interest in a place being re-rented the day after they leave. Here's the interest. If they have a security deposit, the single biggest factor in my mind for a tenant getting full deposit back, the one common thing that I see happening most with tenants that get a full return of their deposit is that the day after they left, somebody else moved in. It shouldn't be that way, but it just is. Landlords have limited time to make repairs. If they get the keys to the unit at noon when the current tenant leaves and the next tenant's moving in the next day at noon, how much are they going to be able to do? And so they might overlook some things, whereas if it's sat empty for a month or two, the landlord might really dig in and find some problems that they hadn't noticed at first glance. And so a tenant really does have an interest in having their place re-rented. But in this sensitive time where tenants are nervous about having anybody invade their personal space, whether it's with a key or even having a guest come over, and some tenants have very high sensitivity for the COVID-19 area. They're immunocompromised, they're incredibly high risk, and they don't want to have any connection with people that's not completely necessary. I've seen landlords that say, you know what, I need to do a showing. We're going to limit the showings. We're going to only do really serious showings, no tire kickers coming through. If you're able to leave for an hour and a half and make the place look presentable as nice as you can, I will give you a gift card for $20 so you can take the kids and go swing through the Taco Bell drive-through and eat in the park and have a picnic of it. And then that, we'll leave a couple windows open when we go to air out the house, and we'll wear gloves and do everything they can to put the tenant's mind at ease. So the question that was asked said, what is the best way to enforce a walkthrough? And in my mind, it's maybe the wrong way to think of this from a landlord's perspective. It should be, what's the best way to encourage or I don't want to use the word convince, that's too strong, but incentivize the current tenant to allow a walkthrough right now with this heightened sensitivity that they have. And again, I assume that's for a showing that the landlord wants to do the walkthrough. Longer answer than I probably needed to give, but that's okay. We have a couple more questions now.
Yeah. All right. Another question from someone. Do you feel a broken air conditioning unit, rent escrow in court over a broken air conditioning unit would hold up in court, considering we're going into the cooler weather months here?
Yeah, it's a good question. And when I saw that question popped up, I grabbed my phone and I looked at the weather prediction for the next couple of weeks, because that's the question, right? I mean, is it going to be hot? Do you really want to do a rent escrow where you're talking about your air conditioner doesn't work when it's 45 degrees out? So a rent escrow, for those of you that don't know, is a court case a tenant files against a landlord, usually used to force a landlord to make repairs that aren't being made. It's actually quite a powerful tool for tenants. It's pretty useful and it's very user-friendly. It's designed to be as close to small claims court, conciliation court as we can get. In fact, it's the same price for a tenant as conciliation court, about $70 to file a rent escrow, which they can get waived if their income is low enough. So logistically, to file a rent escrow, the tenant first has to complain in writing. Landlord, here's the problem. You have 2 weeks to solve it, and if not, I can file a rent escrow. After the 2 weeks, the tenant files a rent escrow. They're supposed to get court within 2 weeks of that. So the question isn't, is the weather going to be warm enough this week or next week? It's going to be, is the weather warm enough on October 16th to be able to stand in front of a judge and ask for air conditioner to be fixed? I just wouldn't want to do the case. If I were a tenant, I wouldn't want to be arguing that with a straight face. Now, there's a chance on October 16th it's going to be warm enough to justify using an air conditioner, but there's not going to be many of those days left at that point in Minnesota. So I guess I'd probably try to talk a tenant out of it. I think it's fine to give a repair demand right now. You could argue for an emergency tenant remedies action, but that's not explicitly covered by the ETRA statute. So I just don't know that it's going to work for a tenant at this point in the year. It's a realistic question. I can tell from the question that they're thinking about it realistically, and that's the realistic answer.
And then a question from Mary. Do you think there's an argument to be made that housing authority cannot terminate a voucher at this time, either under the Minnesota moratorium or even the maybe the CDC related one. It's not a termination of lease, nor is it an eviction, but a tenant with no voucher to help pay the rent for a low income person would ultimately is going to result in eviction.
Yeah, it's a fair question, Mary. I don't really agree with the last part of what your question says, though, that the result will be eviction. That implies that there will be a court case filed against the tenant, which I don't think is a necessary conclusion here. So if the housing authority ends a voucher, terminates a voucher, there's a lot of reasons why they terminate vouchers. It isn't commonly done, but there's a wide list of reasons why they can do it. It's not necessary that an eviction would follow. What will happen is the housing authority will stop paying, ultimately at some point, the tenant's rent. So the landlord's not getting full payment. But right now they can't file an eviction for non-payment of rent. So the tenant still couldn't be evicted right now, at least in Minnesota, under that Minnesota moratorium on evictions. And if the tenant left the day the governor lifted the order, or the state legislature lifted the order, and the CDC order doesn't somehow play a role here, then the landlord couldn't file an eviction. If the tenant left, the landlord can't file an eviction if the tenant is not in possession anymore. So this is one of those situations where if it happened to a tenant, we'd want to talk to them, or they'd probably want to talk to legal aid and look at their realistic choices. If one of their primary goals, and this is a very important goal, is to keep the eviction off their record, leaving sort of, at the last minute might be the best strategic move for the tenant in that situation, to keep an eviction off their record. Now, the landlord might still sue them for money in a different court, but they would keep the UD, unlawful detainer, eviction off their record, which is very meaningful for most people applying for housing in Minnesota still.
Although that they will have lost their voucher, which is also
oh yeah, there's no question that that's a huge impact on the tenant, but that's not really what this question's asking. It's more about, hey, should that ability be stopped during COVID-19 because it would lead to an eviction? And I just don't think that that's an automatic eventuality if a voucher is lost right now.
Right. The Minnesota suspension says the landlord cannot terminate a lease. And in this case, that landlord would not necessarily be terminating the lease. It's the housing authority terminating the voucher. And so,
which is a different question. Yeah.
Right. And ultimately that, it's not a good situation for somebody to be in, but, again, the tenant would feasibly be eligible to get housing assistance through the state program that could help them at least temporarily if they were trying to find another place or secure some other subsidized housing. Another question that just came in, and we have a few minutes until 3 o'clock, so we'll tackle this one and then probably call it a day unless there's any more that come in. Robert says, I have a friend who says his landlord gave a handwritten note stating he has to vacate the property in mid-October and force him to sign it, which he did. He's already paid for his October rent, which was accepted by the landlord. My understanding is that a landlord cannot give a notice to vacate right now. And since the rent was already accepted for October, he's able to stay the full month. What can he do here? Okay.
A lot of stuff in that question. One of the things that Robert said was that the tenant was forced to sign it. There's a legal term for that. It's called duress. But it's not as broadly applied as people like to think it is. When it comes to a contract signature, duress, and I don't mean to be extreme here, but it might be somebody literally holding a gun to your head saying, sign this or else I shoot. That would be duress, no question about it. That's on one end of the spectrum. On the other end is the person signs it completely willingly, nobody around them pressuring them at all. And you've got to get pretty close to the gun to their head. The notion that you'd lose your housing if you didn't sign it, is that enough duress? Probably not. So the concept that the tenant was forced to sign something, a question that we get a lot. I was forced to sign something. We actually ask them that question. Okay, tell me about how you were forced to sign it, literally. And it's almost never up to the level legally of duress. But let's just ignore that for a second because I'm not sure how relevant it is. We have some more facts here. Number one, the tenant paid all of their October rent. So that's what I'm gathering from the question. The full rent was paid for October, even though they're supposed to leave by October 15th. But assuming that the governor's moratorium does not go away on October 12th, could the landlord force the tenant out on October 16th? Right? Because they're supposed to leave by October 15th is what this question is asking. And the short answer is, I don't know how. How would the landlord force the tenant out if the tenant refuses to go? The landlord would have to go file an eviction, but right now they can't file an eviction for that reason. What it would be, the reason the landlord would check off on the eviction page, there's a box, you have 4 or 5 boxes of things that you can check off for a reason for an eviction. And the box the landlord would check here would be something called holding over, that the tenant is holding over past the time they were supposed to leave by. And that's not on the list of reasons why a landlord can file an eviction in Minnesota at present. So it would get us past that point. There's an argument as well that the landlord has waived the right to evict for October by accepting full October's rent. That's not a sure thing, but it is an argument that the tenant could make. If Robert's friend stays past October 15th into November, pays November's rent, and the landlord accepts it, then there's no question that that notice to vacate is gone. The landlord knowingly accepted rent after the time that the tenant was supposed to vacate by. They've waived, that's the legal term, they've waived the right to file the eviction in that context. The last part of this that sticks up in my mind is that the question that Robert had was that the landlord can't give a notice to vacate right now. That's right, a landlord can't unilaterally terminate a lease. The tenant would say that they were forced to sign it, but the landlord would say, no, this was an agreement between both sides. The tenant can certainly give a notice to vacate. And so I don't think that that's the winning part of the argument for Robert's friend. Their best argument is going to be if the governor's moratorium is extended and the landlord accepts rent into November, then it would certainly wipe out that notice to vacate by a waiver.
Right. And with 2 minutes remaining, we got one last question here. So
how about that?
All right. So question about housing issues that's now been resolved. Tenant got a letter from a landlord that even though they couldn't evict anyone, they said they would sue in civil court and ruin credit. Then they would evict once the ban was lifted, so she wouldn't be able to find another apartment. Can this be done?
Yeah, we're starting to hear a little bit more of this as landlords are frustrated by the fact that they can't file evictions. So can a landlord file a case in civil court for rent? Yeah, I think they can. I don't know when they'll have that case heard. It depends on the county they're in, how quickly. I assume this would be in conciliation court. That would be the cheapest way for the landlord to file a case. They can sue for up to $15,000 there. And so the case might take, it used to be, I would say, 3 to 8 weeks. If you file a conciliation court case throughout the state, it's usually going to be heard within 3 to 8 weeks. Now, I'm guessing next year, if you filed a case today, and probably well into next year, depending on where you're filing. The landlord's secondary threat to file an eviction once the eviction ban is lifted, so the tenant wouldn't be able to find another apartment. Yep, a landlord could file an eviction if the tenant is still there. If the tenant leaves right when the moratorium gets lifted, then the landlord cannot file the eviction. The landlord, in order to be able to file an eviction, has to swear under oath, under penalty of perjury, that the tenant is still in possession. The landlord wins the eviction. All they win is the right to possess the place. They win the keys. Just think about it symbolically. And they already have the keys at that point if the tenant's given up possession. So the eviction would only make sense if the tenant is still in possession at that point. Otherwise, the landlord filing an eviction just to wreck the tenant's rental history, number one, would cost the landlord $300. Number two, they'd have to commit perjury. And I can tell you from experience, landlords don't do this. I've seen under 5 in my career where a landlord has filed an eviction once the tenant's given up possession. Every time it was a real murky thing that the landlord wasn't entirely sure if the tenant had left. So if the tenant is planning to leave, they just want to telegraph this and have written proof. I'm leaving, here are the keys, all my stuff is gone. Even if they owe, $15,000 in rent, they still get out. The landlord can't file an eviction at that point because the tenant is no longer in possession.
All right. And then maybe a follow-up to that. Do you recommend that a threat of eviction or a threat of ruining credit be reported to the Attorney General's office?
Yeah, I think any threat of eviction right now, I would report to the AG's office. It can have a tremendous, look, some landlords are sort of immune to the AG's office giving them a call. But most landlords, like most citizens in the United States, they get a call from the Attorney General's office saying, hey, I've heard what you're planning to do and there's a law that you should follow. They tend to back off. And so I like tenants using the AG's office when there's a threat of an eviction for sure.
All right. Well, thanks, Mike. I think that does it for today. We've managed to get to all the questions in the queue. And again, a reminder next week that we'll do this again Wednesday, the 23rd at 1:30. You'll get a follow-up email with information about how to register and the recording from today as well. And so with that, we'll call it a day.
Thank you all.
Thanks. Bye-bye.